Welcome everyone to the Federal Bar Association Key Tem Sections, the rounds, FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald. I am chair of the Key Tem section of the Federal Bar Association with Tejinder Singh, who is a partner at the law firm of Goldstein and Russell. Tejinder, hello.
Hey, Scott. How are you?
I'm good. So we got some things to talk about today. Hey, first, let's talk a little bit about the Cimino case. This is a case about, at least at the surface, about fraudulent inducement, right?
Yeah, that's right. The allegation in Cimino is brought by an insider at IBM, and he says that IBM basically conned the Internal Revenue Service into accepting a software contract that the agency didn't want or need. Basically, IBM falsely represented that the agency was going to owe all kinds of contractual penalties to IBM, but that they would all just go away if the agency re-upped with the new contract. And as the complaint was written, it said three different things about IBM's lies and the effect they had on the IRS's decision-making. It said they were material, it said that they were a substantial factor in the IRS's decision-making, and it also said they caused the IRS to enter into the contract. And the district court read those three sets of allegations and said, look, I don't think you've alleged enough causation. You've only alleged maybe materiality or maybe something else, but just saying it's a substantial factor isn't enough. And so the case went up to the DC Circuit on appeal after it was dismissed. And the DC Circuit said, actually, you did allege enough. You need to allege but-for causation in fraudulent inducement cases, and you allege that the IRS wouldn't have entered into the contract otherwise.
So just as a threshold matter, what's fraudulent inducement?
Fraudulent inducement is when an upstream fraud taints downstream claims for payment. The most typical example is you get a government contract by fraud. You might perform the contract ably, you might deliver everything you were supposed to deliver, and the invoices you send might be totally accurate, but they're still deemed to be false claims under the FCA because you got the contract in the first place by fraud. And this theory is not limited to contracts, it also includes other government benefits. So we've seen cases, for example, about fraudulently obtaining approval for a drug from the FDA or a medical device. The claims for payment for that drug or device could then become false.
And but for causation, it's gotten a lot of press and time at the Supreme Court. What is it and how does it apply here?
The but for causation just means that the event is an indispensable part of the factual chain of causation. Without it, the thing wouldn't have happened. So in this case, without the lies, the IRS would not have signed the contract. That's what but for causation means. Now, it doesn't mean it's the sole cause. It just means it's one important cause of what happened. And that's the standard that applies now to fraudulent inducement claims in the DC Circuit and probably in most jurisdictions.
Okay. Let's talk about Rahimi in the Sixth Circuit, Rahimi versus Rite. What's this case about?
This is an appeal that goes off on public disclosure bar grounds. The Sixth Circuit affirms judgment for the defendants here. And the allegations in the case are about chicanery involving drug prices that had come up in a variety of contexts. So these pharmacies have discount programs, and there's a question about whether they have to report their discounted prices as the prices they're offering to most customers, which is in fact what they are doing, when for purposes of calculating the prices the government pays, which are based on a formula keyed in part to the price retail customers pay. Here, the relator brought allegations that said Rite had engaged in this conduct, not reporting its discount prices. And there had been a bunch of other investigations and cases about this around the country. The Sixth Circuit here, the most important pieces of its ruling, the first thing it does is it rules for the defendants saying, look, the fact that those other investigations involved different defendants and in different states doesn't really matter that much because the underlying conduct is so closely similar that you're going to see governments investigating based on that. It's substantially the same in the parlance of the statute. The second thing that happens is that the Sixth Circuit revisits its own precedent about the original source exception. Now, it doesn't decide that the relator is an original source, but previously the Sixth Circuit had adopted an unduly narrow interpretation of when you have to provide information to the government to be an original source. In the Rahimi case, the Sixth Circuit brings itself into alignment with the other circuits, basically saying if you've provided the information to the government before you file your action, that's sufficient to get you over that part of the test.
Okay, so let's talk about Kennedy versus Novo AS. What's this case about?
This case is about the alternative remedies provision of the False Claims Act. In this case, the relator actually successfully brought an FCA claim against the defendant and got, I believe, a $7.5 million award. Then there was a separate action brought by the government under the Food, Drug, and Cosmetics Act. And the question was, can the relator get a piece of that recovery too? And specifically, the question for the DC Circuit was, is it enough that the FDCA action and the FCA action were based on the same underlying conduct? Or does it have to be the same exact claim, that is, a claim for fraud? And the DC Circuit says it has to be a claim for fraud. It's not enough that it was based on some of the same underlying misconduct or noncompliance. It has to be a fraud claim itself. Now, this raises a pretty interesting question. I think relators have been concerned that what may happen is they'll bring some misconduct to the government's attention through an FCA action. The government will pursue some alternative resolution with the defendant and find a way to leave the relator out in the cold. For example, it may move to dismiss the relator's case or something like that and just proceed in some alternative fashion. The DC Circuit says it's not reaching that scenario. It's not going to talk about it because in this case, there actually was a settlement and the relator got something. And if she thought she was supposed to get more, the DC Circuit says the right time to do that would have been in connection with the settlement because the court has to deem the settlement fair and reasonable. And so she should have raised her objections then. So the DC Circuit leaves for another day what happens in cases where there is no settlement, but in cases where there is one, I think relators and their counsel are on notice that they need to be aware of other possible resolutions the government might pursue and make sure that those are accounted for as well.
All right, let's finish up with United States versus Eli Lilly and Company. Tell us a little bit about this case.
So this is one of these actions where the government has moved to dismiss the relator's complaint under subsection C2A, which gives the government authority to dismiss qui tam actions. The scope of that authority is unclear. It's subject of what the Fifth Circuit describes in this case as an entrenched circuit split, but the court doesn't actually get into the substance of the split. Now, to flesh out the split a little bit, there are two things along which the circuits are divided. The first is procedure, and the second is the substantive standard that applies. Procedurally, there's a split about whether the government has to first intervene before moving to dismiss a case. The Seventh Circuit has said yes. The other courts that have considered the question so far have generally said no. And the Third Circuit is considering a case where the argument has been squarely presented and very well briefed. And so there's a question about whether the government has to intervene. Now, normally at the start of a case, the government has carte blanche to intervene. So it's not a big deal, even if they have to. But the issue arises when they try to dismiss cases later on, because belated intervention can only be done for good cause. And so there's an argument that if they have to intervene first, they also have to show good cause, which might mean telling the court something that the government didn't know at the time they declined to intervene in the first case. The substantive standard is also the subject of a split. So some courts, like the DC Circuit, have said that the government has basically unfettered discretion to dismiss qui tam complaints. Some courts, like the Ninth Circuit in its Sequoia Orange case, have said it's more like a due process standard. And then the Seventh Circuit had a case where it said basically the government has to meet the standards that would apply based on the stage of litigation, whether it's before or after summary judgment. But before summary judgment, they have a ton of discretion, and after, maybe not. So there's that split also percolating. The Fifth Circuit doesn't really get into the split. It reads the Sequoia Orange standard as the more relator-friendly standard and says that because the relator would fail under that standard, there's no need to resolve which standard is actually correct. But this just sort of tees up an issue that keeps bubbling around in the lower courts.
So one of the issues here is whether you actually have to, if you're the government, go before a judge, right? And at least explain what the government's position is.
That's correct. So the statute itself provides, this is section C2A, that if the government is going to move to dismiss, the relator has to get notice and a hearing. But strangely, the statute doesn't say what you talk about at the hearing. And some district courts have joked, like, does this hearing do anything? Is the court's function solely to serve donuts and sit around while the government tells the relator that it's dismissing the case? And the government has in the past taken the kind of that position, that really the purpose of the hearing is just to give notice, as opposed to involving the court in any substantive decision-making. Most courts have reasoned that there has to be some kind of inquiry at the hearing. The government has to say something, but they've varied quite a bit in terms of how much scrutiny they would subject those claims to. And this is actually the topic of an ongoing effort to maybe amend the False Claims Act, where they're talking about inserting substantive standards about what will be discussed at the hearing.
So what's your takeaway from these cases, and in particular this case? What does it add, and maybe what's the lay of the land now?
The lay of the land remains that if the government wants to dismiss a relator's case, almost certainly they're going to find a way to be able to do so. Courts have been very solicitous of the government's decisions to dismiss relators' cases. I think there are real questions about what kind of showing the government should have to make, depending on the procedural posture of the case, depending on how long the government has let the case run. For example, if the parties have been litigating for 5, 6, 7 years, and there's been discovery and all that, and the government has just been quiet, I think it's a little bit unreasonable for the government to show up and say, okay, we're moving to dismiss this case, even though for our purposes, nothing has changed, right? We don't know anything different than we knew 7 years ago, but we've just decided that now is the time to get rid of the case. I think that sort of thing where there's a lot of reliance interests in play, you might see courts look at it a little differently. In a case like this one, the government skated through in part because this relator had brought multiple complaints and the government had moved to dismiss multiple of them, basically concluding that there was no merit to the relator's claim and that the relator's claim actually threatened some elements of US policy. And so that seems like a situation where the government is overwhelmingly likely to prevail, where they make those kinds of representations. I think that courts are not going to look behind them a lot. And the relators, to their credit, they did have good arguments that actually this is not against government policy. We have, the better case here for why the case should go forward. But I think courts are inclined to be very deferential. And I think one of the big takeaways is they will be going forward too.
Tejinder, thank you. And thank each of you for joining us for the Federal Bar Association, Key Tam Sections, The Rounds, FCA News with Tejinder Singh. We look forward to seeing you next time.